If it makes one sound, it's mine.
Okay, understood. But I have some questions as to the nature and cause of these proceedings. And also, I'd like to know what the grounds were for the denial of the motion.
I don't need to state.
You don't need to state any grounds, so there are no grounds for the denial of the motion?
I did not say, do not put words in my mouth.
Okay. So then did you have the...
I denied your motion. Plain and simple, mister.
Plain and simple.
Listen to me. Regardless of who you are and what you are and what you may pretend to be, when a person or whomever comes into the state of Florida and drives on the state roads, you agree, that is a privilege. You agree to be bound by the rules of that road. If Prince William comes over here and drives, he must drive on the right side of the road. When I was in England, I had to drive on the left side of the road. When you drive on our roads, that are your roads as well, for the safety of the public, you will abide by the rules of the road. It's just that simple.
I'd also object to that because I don't agree with the definitions. I just like that for the record, the objection noted for the record. I also have some more questions also to the nature and cause of these proceedings, if you don't have any objections.
Sir.
Um,
Okay. And this is fine. You sit down. We will continue. I'm not going to waste everybody's time with you.
Okay.
You will be moved to last.
I don't believe this is a waste of time.
You will be moved to last on the agenda. And I will hear you. You'll have a seat.
You want to postpone this matter?
You will have a seat. You have difficulties.
Under duress, yes, I will, definitely, for the record.
Do you have difficulties with English language, sir?
No, I actually do
Then
not.
you sit
Thank
down,
you.
right there, in that chair. Sir, put him in, right there.
This one?
I am not going to make everybody in here, officers and public, sit and listen to me deal with you. When everyone else is done and they've gone about their business, then we'll listen to you. Plain up. Okay. Do.
Number 3, Carlos Masonava.
He's going to have some issues as to or some questions as to the nature and cause of these proceedings. If I could ask the judiciary some questions as to the nature and cause, Your Honor.
Okay, sir, you're charged with speeding. You're charged by Deputy Heasley with doing 74 and a 35. How do you plead to that?
I would like to plead as soon as I get the questions as to the nature and cause of the proceedings before I can make a plea.
You are in Harding County Civil Court. I am Civil Traffic Court. I am the duly elected county judge of Harding County. I'm a member of the Florida Bar, a citizen of the United States.
And Your Honor, is this a civil action in the form of tort or contract dispute?
It is a civil violation as determined by our legislature.
It's a civil violation? It's not criminal in nature?
No.
Well, I'd like to dismiss the case against me because there's no actual plaintiff. I haven't actually seen the plaintiff yet.
Motion is denied.
And what grounds?
I don't think the stated grounds.
Is this a court of record?
No. Yes and no. We do not record the proceedings. Technically, it's not.
So this is not a court of record. Are your decisions bound to the Constitution?
Yes.
I'd like to submit some evidence. Oath of office signed by you, certified copy. It's 2006 and the 2012. Is that your signature on the paper, sir?
Yes, sir. This is my oath of office.
Is this going to be an administrative or judicial proceeding?
It's a judicial proceeding.
Are you bound by the rules of Florida Rules of Court?
We're under the rules that pertain to traffic court.
Under traffic court, anything that's not governed by traffic court, are the civil rules apply? That's not governed by the actual specific terms in the
The
traffic.
rules as prescribed by the Florida Supreme Court that pertain to traffic court.
So, are the charges against me strict liability charges?
They are civil in nature.
Civil in nature.
And it's not a liability issue.
It's not a liability. This is not a liability issue.
No, sir. We are not in tort.
Am I innocent until proven guilty?
Sir?
Am I innocent until proven guilty?
Yes.
In order to prove my guilt of the charges against me, will the prosecution be required to prove all elements of the cause of action?
As the elements of the cause of action are determined by the legislature, yes.
In this case, will the court recognize cause of action that's mandated by the Supreme Court? So in order for that cause of action to be fulfilled, is there a need for an injury, loss, or harm?
No,
There's not for a cause of action?
no. We're not in tort.
Okay. You said we are in civil, correct?
That's correct. It is deemed a civil infraction.
And once again, sorry for the restatement of this question, and you said this is a court of record, correct? But you said it's not on record.
Correct.
So, will you be posting an indemnity bond in this case?
No,
No. If this case is appealed, will you post an indemnity bond?
it's not necessarily to post an indemnity bond to appeal this. You may appeal my decision to the circuit court.
Do you have to post an indemnity bond in court?
Do I?
Do you have to post an indemnity bond? Do you carry any type of insurance policies to indemnify anybody in any actions that you preside over?
My actions while I sit in this courtroom. I have a judicial immunity.
Sorry for my time. It's going to take me a couple minutes. Excuse me. Pursuant to your oath in your performance of your official duties, including those before this court, are you required to abide by that oath? Is that correct? Are you in any relation, do you have any relations with the plaintiff in this case?
Do I have relations with whom?
Well, and do you have any type of contact relations, or do you receive any type of benefit from the actual plaintiff as far as like, compensation for your services or anything like
I
that?
am paid a salary by the state of Florida for sitting as a judge.
Well, I motion to dismiss based on conflict of interest.
It's not a conflict. It's not a conflict because my salary does not change by whether I find you guilty or not guilty, nor does my salary alters in any way by the amount of penalty that I assess. So your motion is denied.
Does this court recognize due process of law?
Yes.
Has any evidence in this case been presented as to the jurisdiction of this case by the plaintiff?
I'm taking jurisdiction.
You're taking jurisdiction?
I have jurisdiction as the county judge over civil traffic.
Has the plaintiff,
I have chosen not to relinquish that jurisdiction to a hearing officer.
has any evidence been produced that the constitutional laws apply to me?
This is the third time I have told you that we are bound by the Constitution.
No, I understand that. Let me rephrase that. I said, has any evidence been produced to prove that the constitutional laws apply to me? I know they apply to you because you have the oath. I understand that. But I was wondering if there was any evidence that was presented within this case that the constitutional laws apply to me, specifically by the plaintiff, not by the judiciary, but by the plaintiff. Has any evidence been produced?
The protections, it's one of the great freedoms and blessings of living in this country. Any person that is in this country is entitled to protections, whether they be a citizen or not, as long as they're not an armed combatant or deemed a terrorist.
Am I entitled and guaranteed to a fair and impartial trial presided by a fair, unbiased, impartial judge before and decided by juries of my peers?
You're not entitled to a jury trial in this. You are entitled to a fair and impartial trial.
Is there somebody that's representing the state in this action?
Pardon?
Is there somebody that is actually representing the state in this action?
The state presents, in the form of an officer, presents testimony, and I rule on that evidence. The same privilege to present evidence as is allowed to you. Neither of you need to be lawyers.
Proof consists of verified and demonstrated competent evidence and no opinion, especially opinion unsupported by fact, law, and evidence. Is that correct? Would you like me to restate
In
that?
civil traffic speeding cases is what this legislature says is allowable. The legislature and the Supreme Court.
Was there a complaint filed in this?
The citation may be interpreted as a complaint.
And complaints are causes of action again, correct?
There is not a cause of action. There is a citation.
There's no cause of action when I move the motion to dismiss based on there's actually no cause of action. Okay, it's for the record.
There is no record,
That's my record.
as you say.
So if this is not being recorded, then how is any of this preserved for appeal?
That's your problem.
It's my problem. So this isn't a court of record then?
Correct.
Then it isn't a court of record.
The record is my memory.
The record is your memory?
That's correct.
I motion to dismiss based on a
Motion is denied.
an inability to provide a fair and impartial trial because there's actually no record in which.
Sir, you have the opportunity to have this proceeding recorded. We do not put the state of Florida to the cost of recording civil traffic.
Would my recording be able to be used as evidence?
If you are able to have it transcribed and present it, that will be a decision to be made by, in this, more than likely, our chief judge.
Well, for the record, can you please state and spell your name?
Sir?
For the record, can you please state and spell your name for my record, because that way I can be transcribed properly.
My name is well stated in your pleadings. It's not necessary to do it.
So you are Jeff J. McKibben, correct?
Yes, sir.
Address, Post Office Box 2532, Wauchula, Florida 33873.
That's correct.
Once again, I demand dismissal because there's definitely an inability for me to produce record for appeal. Therefore, all my issues would become muted by the court, and I believe that the court is mandated to provide a record for appeal.
That's incorrect.
Are you going to provide evidence for the state?
Am I? No.
Are you a witness for the state?
No. Okay, we'll proceed. Raise your hand, please.
I object, Your Honor. But no witnesses have been called. I have not entered a plea.
Objection duly noted. You swear or affirm the testimony you give this morning will be the truth?
Yes, sir.
Okay. Would you explain the circumstances by which you issued the citation in this case?
Monday, the 28th of April 2014, approximately 2:43 p.m.
Objection, Your Honor. The witness is reading from notes.
You may proceed.
I was monitoring traffic at 17th and 7th Streets West. Whenever I noticed heading southbound was a blue and white sport bike. I saw how I estimated that vehicle would be traveling at 72, 73 miles an hour. I activated my dash mount stationary radar using my front antenna. It had a very loud Doppler sound. The display showed me that the vehicle was traveling 74 in a 35 mile per hour zone. I knew that the vehicle was moving very fast. I might not have a chance to catch it, so I used my binoculars, which were set beside me. I obtained the license plate number from the vehicle. I proceeded after the vehicle. I followed the vehicle from College to just south of Golden Oaks with my lights on, alternating with my sign to bring it to his attention where we were traveling approximately 84 miles an hour in the 60-mile-an-hour zone. The defendant pulled over to the side. I conducted a traffic stop. All of his paperwork was up to date and proper. The stop was very cordial. He was issued his summons and free to go.
Now, where did this start?
Objection, Your Honor. I don't believe that you're allowed to ask the questions or ask leading questions. I believe that is up to the plaintiff. I don't believe that you're in a position to ask questions and represent the state. That would be practicing from the bench. So I would ask that you would refrain from asking the witness any questions.
We are in civil traffic court. I am not asking about the essential elements. I am asking for my clarification and edification. Where were you sitting?
I was sitting
initially?
at 17 and 7th Street West, just south of the John Deere dealership.
Okay. And he was south now.
Yes, sir.
And you recorded this on, the ticket says on the Golden Eagle to your regular.
Yes, sir. Serial number XE06.
Okay, and I'm billed your, okay? You may question this witness about the facts that he stated. And you may inquire.
I can question him about the facts that he stated, or I can ask him questions about the facts in general that pertain to this case.
Of what?
Can I ask
You may ask him questions about
his statement,
testimony.
about his testimony? Can you state your name for the record?
Deputy Scott Easley.
Do you have an oath to uphold the Constitution?
Yes, sir.
You will ask him questions about the record, about his testimony.
What record?
He is not here to discuss civics.
What record are we talking about?
You may ask him questions about his testimony.
I don't know what that is. There's no record.
Sir?
There's no record, so I don't really know
You may
what that
ask
is.
him questions about his testimony. I presume you can remember what he just said. I assure you.
Can I have it read back to me?
Sir?
Can I have the record read back to me? Because
There is
I
no-
can't recall exactly what he said.
You may ask him questions.
About,
You may ask him questions.
thank you. Thank you. Let's see. Was it a sunny day out there with no clouds in the sky, correct?
Yes, sir.
Officer, the roads were dry and free of debris, correct?
To the best of my knowledge, yes, sir.
Officer, there were no other automobiles on the road at the time that you detained me, were there?
Yes, sir, there was. As a
Um,
matter of fact, you passed several of them.
Were there any pedestrians near the scene at the time that you detained the traveler?
Excuse me, sir, I didn't understand the question.
Were there any pedestrians near the scene at the time that you detained the traveler?
Not to my recollection.
Were there no or actual potential hazards that you were aware of at the time of this citation? Were there?
The hazard that I did see was the speed you were traveling at, sir.
Speed determines hazard.
Yes, sir, it does.
How fast did you say that I was going?
The radar said it stated you were going 74 miles per hour, 35 mile per hour zone.
Okay, so hazards, like you said, hazards are, when someone speeds, that's considered a hazard, correct?
Yes, sir, because you don't know what the next person's going to do unless you're reminded.
Okay. What was your speed when you pulled me over?
When you finally pulled over, my actual speed was 84 or 86 miles per hour.
That's what your speed was, correct?
That's what your speed was, along with mine.
Along with yours? Once again, you did take an oath to uphold the Constitution and laws of the state of Florida, and I believe that would apply to you. And in that regards, do you think that the speed limit should be applied to you?
That question has nothing to do with our traffic stop, sir.
Well, it goes to your credibility, and it also goes to, well, regardless, it's still a question. Do you believe that you are exempt from the speeding laws, or the speed limit, or the limit on those roads? Do you believe that you are exempt?
That's a very open-ended question, sir.
It's yes or no, it's not open-ended. It's absolutely not open-ended. It's yes or no.
When I believe my speed was justified, when it was to stop you from perhaps harming yourself or someone else.
Motion to dismiss based on the fact that he just stated
The motion's denied. It's not a material element.
speed is not a material element.
No, speed is the material element.
Well, I'm going to the credibility of the witness.
Sir?
Credibility of the witness. I'm not going for any of the elements. I'm just going towards the credibility of the witness.
Ask your next question.
So for the record, that was a non-response. I had a motion to dismiss based on non-responsive
Motion denied.
witness. Are you? Do you apply statutes to drivers and travelers and
The
people?
state of Florida does, sir.
So you don't enforce the law?
Yes, sir, I do.
Enforce the law.
Sir. You may question him about his training, you may question him about his qualifications with the radar. We are not launching into a general discussion of statutes of all these extraneous issues. Proceed.
Well, I would like to object to that for the record, but there's no record. In your training, do they issue you a book that would contain the statutes?
Yes, sir.
Did you take any classes or prepare yourself to apply those statutes?
Yes, sir.
Did you apply a statute to me in this case, or the alleged defendant?
Yes, sir.
Can you tell me what that statute was?
Statutes, Florida State Statute 316, 187, 2C.
Once again, I object. He's reading from his notes. It's not from recollection. I'd also like to motion to dismiss based on the witness's memory is very poor. He's having to refer to notes.
Are you qualified to, what's your medical background to qualify you to make a statement about his memory?
About his
That's
memory?
an opinion testimony, sir. What's your background?
I'm not stating it as an
Okay,
expert
then you're
witness.
not
I'm stating it
saying
as in
motion's
him
denied, overruled.
him reading from
Proceed.
the actual.
Proceed, support.
Do you have a copy of 316.1872C?
I do.
May I please see it?
Yes, sir.
And make a judicial, mandatory judicial notice of it? Can you tell me how 316, would you like to see this?
Please.
Can you read that for the record, please?
The Department of Transportation is authorized to set such maximum and minimum speed limits for travel over other roadways under its authority as deemed safe and advisable, not to exceed as a maximum limit 60 miles per hour.
Can you tell me how that statute applies to me?
He was exceeding the posted speed. He was exceeding the posted speed.
Yeah.
Does it state in that section about if anybody violates or anything like that?
In that particular one?
Yeah, that particular one. To my recollection, it says that it's just that's part of the statute's actually giving authorization for you to make speed limits, but doesn't say, about any violations thereof or anything. Did you write the complaint?
There is no complaint. I have stated that before. Move along. You may ask him about the citation.
And you stated that the radar used was the Golden Eagle 2 radar?
Yes, sir.
Do you have a calibration certification?
Yes, sir.
Can I have that entered into the record?
Sir?
Can I have that entered into the record, his calibration certification?
We will make a copy, or I will look at that. You want to see it?
Oh, yeah, I definitely would like to
Okay.
see it.
We will make a copy for the record and return. Return the original to the officer's notebook.
When was the last time that this device was certified?
It should be stated on the document, sir, you have in front of you.
December 17th, 2013, is that correct?
If that's what's stated on there, sir.
Who did the certification?
Should be stated on the paperwork, sir.
I don't see it. That's why I'm wondering. I'm asking. Can you please point it out to me? I just set it there. I might get it back.
States right here, sir. Right there's electronic technique. definition right there.
How long do these certifications last before? How long does or how often does the device need to be recalibrated?
It's recalibrated every 6 months, sir.
Do you know how they recalibrate it, or do you not? Are you not an expert
No,
in
sir,
that
that's an
area?
outside agency that takes care of that.
I'd like to subpoena Michael A. McGill as for testimony on the certification.
This is a mandatory hearing. You had the opportunity to have whoever you want to hear here. There's no request. The court did not receive a request for any subpoenas nor any shown in the file. The request is denied.
I'd like to motion to dismiss based on the qualifications of Michael A. McGill. I just do not believe that he's certified or he's qualified to make this determination. And there's no evidence on the record, and I don't believe the state has provided any evidence thereof.
The legislature has deemed that when an officer comes in here and offers sworn testimony from a radar thing, it's properly certified, it's been certified, provides the information, there's a presumption of correctness.
Until it's rebutted, I deny that presumption.
Offered no evidence to rebut.
Keep talking, it's not even recording.
Proceed.
Is this thing really not recording at all?
Sir?
This really isn't recording at all. Once again, for the record, you are not the. You're not the plaintiff, correct? Was I involved in any commerce when you pulled me over?
Involved in what, sir?
Any commerce?
Can you explain your meaning of commerce?
Commercial activity that would result in financial gain?
As far as me,
No,
sir?
me.
I wouldn't know what you were doing that day.
But you don't know if I was or wasn't. But you observed that I wasn't in doing any commerce or commercial activity at the
only thing I
time.
saw, sir, was you were speeding on the roadway.
Was there an injury involved?
Not to my knowledge.
Was there any loss involved?
Not to my knowledge.
And was there any harm involved?
As far as physical harm, not to my knowledge.
Once again, I'd like to motion to dismiss for failure to demonstrate a cause of action in which relief can be granted.
Denied.
Grounds?
What, immateriality.
Have you provided any evidence that the Constitution and laws apply to me?
Outside the scope, move along. Okay, that's enough. You have 5 minutes to tell me whatever you want to tell me.
Well,
You have 5 minutes to tell me to present your closing argument. Or witness, do you have any evidence?
do I have any
Do you
evidence?
have any evidence to overcome the presumption raised by the state?
To overcome the presumption, yes, I actually do.
Evidence.
There, let's see. What,
Do you have any
maybe my
witness-
testimony?
Do you have any witnesses?
Maybe my testimony,
Are
would that
you
be
going to
considered
swear
evidence?
that you were not speeding?
Am I going to swear? What do you mean?
Sir?
What kind of question is that?
Well, that's my question.
No, I didn't,
What
no,
evidence
no,
you
I
gonna-
asked for the state.
What evidence are you going to present that you were not speeding?
Do I need to present evidence to,
The state, I'm ruling that the state has established a presumption of correctness as specified by the legislature. We have
based
sworn-
upon the evidence
If you
of
interrupt-
what?
If you interrupt me again, young man, you will not have a good day. Now, I am ruling the state has established with the presumption, and is entitled to the presumption that you were speeding based upon the sworn testimony of the officer and backed up by the radar reading. You now have the burden of overcoming that presumption by evidence. Do you have any evidence?
Define evidence, because I wouldn't know what it would mean in this
That's for you to
specific.
define evidence. You're the one that's chosen to play lawyer. Do you have any evidence? Yes or no?
Good question. I don't actually have any evidence. I would actually have a question
You
in
have
regards
5
to that.
minutes to make a closing argument.
I have 5 minutes to make a closing argument.
Sir?
Once again, this needs to be dismissed based on lack of jurisdiction.
There will be no motions. You may make your closing argument.
The court has no jurisdiction. The court never had any jurisdiction. There is no cause of action. A cause of action consists of an injury, loss, or harm. This is a civil proceeding that is governed by the Florida Rules of Court, which is also governed. This particular proceeding is governed by the traffic rules of court, but any rules that are not written or published within the traffic rules of court, everything else will be governed by the Florida Civil Rules of Procedure. The Florida Civil Rules of Procedure deems that there must be a plaintiff and a defendant. There has not been an accusation that there was the denial or the violation of anybody's rights, any individual rights. The plaintiff has never alleged that I violated any of its rights. The cause of action has been recognized by the Supreme Court, as what I've just stated. Also, The duty of this court, as of every judicial tribunal, is limited to determining rights of persons or of property which are actually controverted in the particular case before it. Tyler versus Judges of the Courts of Registration, 179 U.S. 405. That's a Supreme Court decision. I'd like you to take mandatory judicial notice of that. The basic elements of a cause of action is the violation of a legal right or loss or harm. The alleged plaintiff, again, acting ostensibly through Officer Hensley, never even alleged that there's no corpus delicti in this proceeding, even though you said that this is not criminal in nature. I feel that if I didn't cooperate or something along that lines, that I would lose my rights and I would be imprisoned or I would be held against my ability. So this, in my ideas, would be a criminal proceeding. I would also, let's see, what else do I have? There's no record anywhere. There was no evidence at all presented that the constitutional laws apply to me. The presumption falls on the actual plaintiff to provide evidence in any case or any cause of action, and evidence that certain things apply to him, laws and constitutional laws apply to him, should be produced. There's also a conflict of interest between you, the state, and the witness, as I believe there is coercion and collusion. The court's jurisdiction is not enlarged by policy authority. The jurisdiction of the court is limited to protecting the rights. This is not enlarged by alleging the police have authority to issue tickets. Allegations will be denied, and allegations without supported fact are not fact. Such authority does not work to trump fundamental limitations on the courts. The amount of police authority may enlarge the limits of the adversary system, but the adversary system it is, and the adversary system requires true adversaries. This requires the allegation of proof of injury. The plaintiff has failed to make such allegations. As a matter of fact, he has stated that there was no injury, loss, or harm. He specifically stated that. And yes, the police may have the authority to issue traffic tickets. They still must allege an injury for the court to proceed with jurisdiction. I do not believe that you don't have jurisdiction over cases that have injury, losses, or harm. I do not contend that. I contend that the actual jurisdiction over this matter, because there is no injury, loss, or harm, the court has no jurisdiction and cannot entertain the actions of somebody without those allegations and that cause of action. I believe that this is not a court of record because there's no recording. It's based on recollection. Therefore, it's de facto, and it is not going to be fair and impartial upon my benefit. I wouldn't be able to, on appeal, I wouldn't be able to recall all of this from my own memory, and I wouldn't expect anybody else to do so.
Time. I find for the state. Record 103 and 65 once before. You were doing 75 and a 50. You were doing 95 and a 65. This is the third time for over 30 miles over the limit. I adjudicate the points. Thank you. We're finished.
All rise, please.
And that's why he was talking so quietly.